I've sent the link to Hermione.
Okay, excellent. Let's just wait for her to join before we start the webinar. Can you see anyone waiting in the waiting room?
No.
No? Okay, don't worry then.
Yeah, because I don't have access to that, yeah.
Okay, so we are recording. Let's just wait for Hermione to dial in. Fingers crossed that she'll be able to. Yeah. How is she doing? Do we know?
Not sure, haven't received feedback yet.
Should I not speak to people that have already joined to just ask them to wait?
We haven't started the seminar just yet, but if you like to, we can, if you would like to do that.
Okay, then I can at least just ask people to,
Yeah, okay.
be patient.
All righty, so Ola, if you can do the countdown and start webinar, that'd be great, thank you.
No problem. Start the webinar now. 5, 4, 3, 2, 1.
Good afternoon, everybody, and thank you for joining this webinar hosted by FTI together with Corruption Watch. And if I could ask you to just be patient for a few moments, we're going to give more joiners an opportunity to log in. And we do have one of our panelists struggling to get access. So if you could please be patient for another minute or two, we'll hopefully resolve that soon. Good afternoon to all of you that have joined since I spoke last. We're just waiting a few minutes to give everyone an opportunity to log in, and we're trying to resolve a small technical hitch that is inhibiting one of our panelists from logging in. So please be patient. We'll start as soon as we can. I'm told that our last panelist has joined, so we can now officially get underway. And so once again, thank you to all of you that have joined us on this webinar. The purpose today is to explore deferred prosecution agreements as a mechanism that can be used as it's used in other jurisdictions, potentially used in South Africa, in a way, in order to resolve complex commercial crime matters, frauds, corruption, and the like, and whether it can make a contribution to speeding up the criminal justice process that we live through at the moment. We have a wonderful panel for you today, so I'll start off by introducing our panelists. Firstly, I'd like to introduce Karam Singh from Corruption Watch. He's the head of investigations and legal at Corruption Watch. He spent 6 to 8 years in senior management in various roles, leading public organizations and global philanthropy. His interests vary in the areas of anti-corruption, human rights, social justice, and access to justice. Most recently, he led the Open Society Foundation Access to Justice initiatives. He also held positions at the South African Human Rights Commission, in particular, with particular expertise in the area of socio-economic rights. Karam's formal training as an attorney, both in the United States and South Africa, and he remains an admitted attorney in South Africa and the state of New York. So Karam, welcome. Thank you for joining us. Our second panelist is Advocate Hermione Cronje. Hermione was appointed in May 2019 by President Cyril Ramaphosa to a 5-year term as the head of the investigating directorate in the Office of the National Director of Public Prosecutions. That was very shortly after the directorate was established. Just by way of background, the Investigative Directorate is tasked with investigating common law offences, including fraud, forgery, uttering, theft, and any offence involving dishonesty. Hermione has a Master's in Public Administration from Harvard University and a BA LLB from UCT. And she's been employed in various capacities within the National Prosecuting Authority, most probably well known in the asset forfeiture space, where she was head of the asset forfeiture unit in the Western Cape for approximately 10 years. And just before moving from the NPA, she was tasked with leading or establishing a multi-agency task team to investigate, prosecute, and recover the assets of persons involved in large-scale corruption. Our second panelist is Advocate Kate Hofmeyr, SC. Kate holds law degrees from the universities of Witwatersrand and Oxford. That's BA LLB, BCL, and MPhil. She was admitted to the Johannesburg Society of Advocates in 2007 and took silk earlier this year. Her main areas of practice are commercial and public law. She's appeared in nearly all the courts in South Africa and is most probably more well known of late in that since 2018, she's been an evidence leader at the Commission of Inquiry into State Capture, Corruption and Fraud in the Public Sector, known as colloquially as the Zondo Commission. And then the fourth panelist is Advocate Gilbert Swats. Gilbert also holds law degrees and was admitted as an advocate in '91. He spent 18 years with the Department of Justice, the tail end being as a deputy director of public prosecutions in the then Office for Serious Economic Offences, which is going back a long time, where we were colleagues for a while. He's conducted investigations and prosecutions in cases of complex financial crime, fraud, and corruption. After leaving the Office for Serious Economic Offences, he went on to lead the forensic division of EY South Africa. Thereafter was appointed the CEO of SABRIC, which is the South African Banking Risk Information Center, which coordinates the bank's fight against financial crime. Went on to head regulatory compliance at FirstRand before independently consulting to the market. So I think you'll agree we have a panel that has experience from across the legal spectrum with a particularly strong focus on fraud and corruption. So with that, let's dive straight into the topic. And maybe I can kick off by asking Karam to give a brief overview. What are deferred prosecution agreements, and how do they work, and what are the advantages?
Thank you. Thanks so much, Petrus. And thank you everyone for joining us for this afternoon webinar, and greetings to my fellow panelists. Before I jump into sort of the definition, I'd like to just take one small step back and give some context as to why this is an issue that was of particular interest to Corruption Watch. I joined Corruption Watch at the end of 2019 and was quickly brought into a process with Transparency International. Corruption Watch is the South African chapter of TI, into a report that they do every 2 years called Exporting Corruption, Assessing Enforcement of the OECD Anti-Bribery Convention. And that report, looks globally at issues around bribery and has had a number of global recommendations and a number of country-specific recommendations for South Africa. So some of the global recommendations included improving beneficial ownership transparency, improving international cooperation, introducing victims' compensation as a standard practice, and establishing high standards for non-trial resolutions. Specifically for South Africa, they spoke about strengthening whistleblower protection, dedicating adequate resources to anti-corruption enforcement agencies. And then specifically, they spoke about the need to approve legislation providing for deferred prosecution agreements. So I found that that specific recommendation of particular interest, and it did inform some discussions that Corruption Watch had with FTI broadly around issues around criminal justice reform. And when we talk about criminal justice reform, at least until recently, the first thing we spoke about was the need for political will. Then we spoke about the need for capacitating agencies of state that had been weakened in the era of state capture. And then we speak about adequately funding these organizations. These are broad. I think those kinds of recommendations still largely exist. But the notion of a deferred prosecution agreement drills down a little bit more specifically and talks about the potential tools that we could add to the arsenal of law enforcement in terms of addressing complex commercial crime. So, with that, that context, deferred prosecution agreement as defined, as the name suggests, is generally a voluntary agreement reached between a prosecutor and a defendant organization, whereby prosecutions for the alleged offenses are deferred in exchange for the organization agreeing to fulfill certain conditions. These conditions are various, and they could exist in various combinations, including admissions to certain agreed facts, the disgorgement of monies associated with the offense, payments of monetary fines or penalties or both, implementations of effective compliance programs to prevent and detect future violations, impositions of monitorship, imposition of self-monitoring and reporting to regulators, full cooperation with regulators in ongoing related investigations, and not repeating offenses or otherwise violating terms of the agreement. So, you'll see with that sort of long laundry list that we're not talking about something which is some kind of get out of free jail card for corporate offenders. We're talking about some kind of a non-trial resolution out of court settlement, which could be subjected to, it could be subjected to court monitoring. It could be subjected to monitoring by law enforcement. And, it's very interesting for me to be sitting on a panel with officials, because it'll be really interesting to hear from their standpoint and their understanding of the types of tools that are available to their colleagues in other jurisdictions, whether this is something which could fly in South Africa, whether this is something which could address, which we're calling a backlog. And it's a big assumption that we're making, a backlog around prosecutions. So, we're certainly not putting this out there as some kind of panacea or silver bullet, but we're raising it as a point of discussion for potential reform of the criminal justice sector and potentially giving our law enforcement colleagues additional tools to pursue complex commercial crimes, often those involving issues of corruption.
Graham, thank you very much. And it's probably a good time to hand over to Hermione to firstly provide your thoughts on the current need for criminal justice reform. There's often reference to the fact that we are experiencing a tidal wave of corruption, or the criminal justice system is buckling under the pressure, or questions have been raised. Is it fit for purpose in its current form? Are these defensible allegations or accusations, or do you feel that there is scope for reforming criminal justice to be more effective when it comes to these type of crimes? Sorry, you're on mute. You're on mute, Hermione.
Thanks. You think I'd have figured this out by now. Thanks, Petrus, and thanks, colleagues. I agreed to participate in this discussion because I feel very strongly that this is an important debate that we need to have in this country. And the issue that we're debating is how to strengthen accountability, how to ensure that, the rule of law is upheld in this country. And it would be foolish for me to sit here and say, no, it's all sorted, we're fine. I have said in the past, I think we have a lot of the tools needed to address serious corruption. I can only speak about my experience with serious corruption in the last 2 years. We definitely have lots of legal tools at our disposal. But in this area, I think that there is room for improvement. But the real issue is the capacity of the criminal justice system to do the basics. But I think the problem that non-trial resolution tries to address is a problem prosecution authorities around the world are facing. It's facing the problem of huge complexity, in criminal matters, in corruption matters. The role players involved are huge multinational corporations, governments, the professions, lawyers, accountants, management consultants. These are highly skilled people, all colluding to act in their own interest and to keep what they're doing from law enforcement and the public in general. And for law enforcement to pry behind that veil of secrecy and those conspiracies, you need very serious capacity and skills. And we have major challenges in all those areas, but we also have a challenge with non-trial resolution. I'd love to get into the specifics, but I certainly wouldn't be sitting here denying that we have a backlog. We have many cases crying out for prosecution, and we are grappling with lots of challenges in trying to bring those prosecutions to court speedily and effectively. I mean, our colleagues around the world are supporting us in these investigations and prosecutions, and we do see the tools that they have at their disposal to move forward on these issues. And the issue of non-trial resolution, I've personally seen in other jurisdictions being used to incredible effect. And even in matters that we are involved in, I'm seeing it being used, and I'm experiencing some challenges in our legislative framework to move forward with those types of resolutions. So yes, there's a backlog. Yes, we have incredible skill challenges and capacity challenges, and there's certainly room for us to improve on our legal framework as far as non-trial resolution is concerned.
Hermione, thanks very much for that. Kate, if I could turn to you, I think one of the contributors to the perception of the general South African public that there is this wave or this backlog is possibly what has been aired in commissions, but there's not always a sound legal understanding as to what is the role of a commission of inquiry as opposed to the criminal justice system. Could you touch on that for a moment and possibly give your inputs?
Yes, certainly. Thanks so much, Petrus, and hello to all my colleagues and all the people who've zoomed in for today. Just a bit of background about commissions of inquiry. I mean, I think there's some perception that they're required to do some of the work of the prosecution service or get cases ready for prosecution. The real fact of the matter is commissions of inquiry generally have 3 questions that they want to ask in the course of their existence. They're usually formed after an event or occurrence of significance within a society, And a chairperson is appointed together with usually a team of lawyers to answer 3 questions. And they are, what happened? Why did it happen? And what can be done to prevent its recurrence? That really is what commissions of inquiry are about. And I also often find it important to reference that in the longer term, I think one of their utilities is that they create a public record that will stand for all time in a society like ours that will bear reference to those very questions. That is not to say that they don't have some link with the criminal justice system, because the outcome of commissions of inquiry are recommendations made by the chairperson of the commission. And it's also important to understand that those recommendations are the high watermark of the power of a commission. A commission has no power to determine guilt or innocence of people, to affect legal rights in that way. Commissions can make recommendations. They often do so in the field of law reform. They can recommend cases to be considered for prosecution based on the evidence that has been produced in the course of the commission's existence. And they can also think more broadly about things like policy change and making recommendations of that nature. So I think in summary, I'd like to say there certainly is a link between commissions and the criminal justice system, particularly a commission like the State Capture Commission, whose mandate has criminal elements within it, right? State Capture Commission to investigate fraud, corruption, and state capture. So it would be crazy to think that it wasn't going to concern itself with acts of criminality. But it's just important to understand the limits of its powers. At the high watermark, it would make recommendations in relation to prosecutions. Thank you.
Thanks very much, Kate. And Hermione, to what extent does the publicity around these commission of inquiries just put your department and your teams under more pressure with unrealistically increased or heightened expectations as to, okay, the first question's been answered, we now know what happened, and that must immediately flow to, so who's going to do something about it?
I think it does do that, Petrus, but I don't think it does so unfairly. I think what the Commission has been really valuable at assisting us with is working out where we should focus. There is no shortage of commercial crime, and there's no shortage of corruption in this country and in many other countries, right? And not all of them are going to receive equal investigation attention. Most people will probably argue none of them are receiving any attention. But what the Commission has done for us usefully is identified, the role players. It's identified the key, what I call crime scenes. The SOEs. The particular government departments where there has been corruption. And so it's uncovered a lot of information that you would normally ordinarily get from Financial Intelligence Center, from the intelligence services generally, saying this is the scope and the scale, crime intelligence, of your problem. In commercial crime, it's not, the intelligence services are not necessarily listening in on boardroom conversations and uncovering the kind of corruption going on there. But what we have seen in the State Capture Commission are the companies, are the professional, the banks, the law firms, all the role players have been identified. And so there is understandable pressure that now we need to see accountability. What is difficult is that there is that expectation that we should act, and I believe that expectation is perfectly reasonable. As I said, the challenges are capacity challenges. There is a sense of overwhelm. The Zondo Commission, the resources deployed to the Zondo Commission and its work has been significant. And I think we've had significant returns on that investment. But the truth is that investment needs to carry over into law enforcement, to equip law enforcement to now take what has been uncovered and turn those that information into evidence and into prosecutable cases. And in that process, there are many challenges. You know, there are challenges just around personnel, straightforward people and people with skills. To know and understand, you know, these commercial settings and the legal ramifications of these arrangements that were concocted to conceal corruption. But then taking the step of actually enrolling a prosecution against some of the big multinational names that have come up in the Zondo Commission. I listened to a webinar the other day where journalists spelled out who were on their hit list of corporates that need to be held accountable. And if you compare those corporates and the budgets they have available for legal resources to defend any kind of challenge that the prosecution might mount, you can understand why we feel a little underpowered in that setting, right? But, you know, what we have on our side is evidence, you know, and so no amount of lawyers, you know, will get you out of the evidence, although they can do a pretty decent job of undermining any effort to prosecute. So I think, you know, we are going to significantly up our game on the investigation and the legal capacity front. But I think what non-trial resolution does is present an opportunity to consider a more practical, a more expeditious, and a more sort of realistic approach to addressing these very real challenges.
Thanks for that. I mean, and Gilbert, if I could turn to you and ask you to possibly, maybe unfairly, speculate a bit, but given the exposure of what happened through the commissions and through the media, and as Hermione has pointed out, the identification of some of the culprits, do you think, bearing in mind Karam's point that a deferred prosecution is entered into voluntarily, do you think the pressure of being exposed at this point in time makes it particularly apt to have DPAs? And do you think big business will use the opportunity to get these matters settled or disposed of?
So Petrus, I'd like to start, well, good afternoon, everybody, to the participants and my colleagues. Maybe we should start and ask ourselves, so what is corporate criminality all about? I think invariably it's a failure of compliance and more particularly ethics and culture. And maybe that's where we need to focus. We've had a barrage of corporate failures, and we've seen out of the commission where corporate criminality arise. But I think if we address, and certainly DPAs provide a powerful mechanism to the prosecutors, not only to pursue the traditional prosecutorial objectives, but actually to impact business ethics. I think we need to look at that aspect of this phenomena. I think the US specifically has been very effective in addressing corporate ethics and business ethics through DPAs, because invariably, if you look at all of their DPAs, the one thing that stands out for me, and coming from a compliance background, is the amount of focus that DPAs put on compliance and actually getting businesses, big multinationals, in fact, to change their culture and change their ethics, because long-term, that's the real solution we want to pursue. Whether then corporates will jump on the bandwagon and come clean voluntarily from a South African perspective is a different question. I think you might find that some corporates may be reluctant. I can tell you, having been in various boards and and committees, risk committees, that entering into a DPA for a corporate is by no means an easy task. You'd probably find that it's a more complex issue than just saying, okay, we'll deal with the criminal prosecution and we'll have a whole barrage of lawyers defending us. It's a total different ballgame. But let me say this, I think it's certainly DPAs is a journey that the NPA should embark upon, no sooner than later, but with a more long-term objective from my perspective of impacting ethics, business ethics, rather than just looking at the prosecution and a guilty plea.
Thanks, Gilbert. Kate, you clearly have some thoughts.
I just want to add something because the themes of accountability have come out from what Hermione's been saying and what Gilbert's been saying. And one of the things I was reflecting on in preparation for today is that my sense is that DPAs work effectively in a system that already achieves a level of accountability. My worry is in a system which is not seen in the main to be achieving the outcome of accountability. Deferred prosecution agreements then can be received as though there's some sort of quick fix to an already failing system. So I think it's quite important to have on our radar that there should be a baseline functioning system, and into that system can be introduced alternatives like deferred prosecution agreements. And I was thinking about one of the ways in which that might be achieved here is to make it a requirement of any such system were it to be introduced. First of all, I do think you'd need legislative reform to introduce it. But in doing so, I think the model that the Serious Fraud Office and the UK uses is quite a useful one, because the whole process has to start with a prosecution. The company must be prosecuted, right? The criminal process must begin. So there's already a signal that it's not an alternative. You have to have a case that's good enough to run as the prosecution service. You have to have an identified culprit, criminal, a company. They don't make it available for individuals. In the UK, that's another debate we might want to have. But assuming you're going to limit it to corporates, you start your prosecution and then the process of DPAs commences. It does have judicial oversight, which again, I think is a security that you'd want to retain in the system. But then you're not, in a sense, sacrificing a form of accountability. You're realizing what the utility could be of then moving to DPAs, which I do think, going back to Gilbert's point, has this ethics enhancing capability. Your conditions can be such that you ensure long-term better compliance from the organization concerned. But you do because you begin it in the criminal justice system and it stays with judicial oversight. You have mechanisms then to monitor it and also to avoid this knee-jerk reaction, which might be we're looking for quick fixes out of a general state of accountability. Thanks.
Thanks, Kate. Sorry, Hermione, you wanted to add a point?
Thanks, Petrus. I know you want to get to questions. So I just want to quickly say I agree with both Gilbert and Kate. I would just say that I agree that this kind of system works well in a country like the US. The US has the FBI, it has the Securities and Exchange Commission, it has federal prosecutors in the US DOJ, and they have a track record, second to none, I think, when they go after a corporate. There is sufficient concern that will result in a prosecution and some dire consequences for the corporate. That is not our reality. And so most accused, never mind corporates, take their chances with the system. You know, people plead not guilty when they know they ought to plead guilty, but there's always a chance that the system will, there's a very good chance that you can play the system sufficiently to get away with it. So in that context, just getting people to the table and wanting to have a discussion voluntarily about how we might address corporate criminality is your issue. Fortunately, one of the things that has happened is that big corporates registered on the US Stock Exchange, all find themselves between these two systems, the US system and the South African system. So you ask Gilbert, do you think corporates will embrace a system like this? Well, corporates are beating down the door saying, please come and sit around the table with us and discuss how we can address this crisis. There are individuals in our company that have clearly acted corruptly. We want them to be prosecuted. We have done our internal investigations. Here's the information. We need certainty around resolving this matter sooner rather than later. So we would like a resolution. We don't want to get sort of an uneven bargain, because we know we are going to be lambasted in the market if anyone believes that we've got ourselves a bargain that we weren't entitled to or wasn't justified because we took advantage of an ill-equipped prosecuting authority. So the reality of the situation is that there are a lot of pressures on corporates in particular to try and come clean. So Kate, while in the UK, you'd start a process with a prosecution. What we are finding is corporates are knocking on our door way sooner than we are ready. So more often than not, we are saying, look, there's imperfect information here. You've done your $1 million investigation into your own complicitness in this. We are at the beginning of conducting an investigation. For us to sit down at this point and say, well, what do you propose? That's a real challenge for us. And that's the issue that we need to be focused on. And my sense is, in a country like South Africa, you almost need in criminal prosecutions, you have the assessors sitting there and assisting the judge in trying to work out, what's going on here. We almost need a panel like that can look at a deferred prosecution proposal and say, that seems fair in the circumstances, if we assume that this is the information, and if more information comes to light at the later stage, well, the whole thing is off the table. But so I just wanted to add that is the reality that we confront, that we building our criminal justice system while we're trying to take on very, very enormous giants. But it's not all that uneven. There are other pressures on all of us to move towards speedy resolution of criminal cases.
To keep on coming back to you, but to kickstart the process, to take the first step, is it possible to do it within the current system, or is serious legislative reform or amendment or new legislation required to create the environment within which to start having these discussions or these trial resolution discussions?
So that's for me again.
Yes, if you don't mind.
So we, as I've said, as I said initially, there are lots of tools on our books. We, as prosecutors, can decline to prosecute even when we believe there's reasonable prospects of a successful prosecution, if the interest of justice dictate that not prosecuting would be appropriate. There are lots of examples. So we can decline to prosecute. We can enter into or agree for a corporate, if they make full disclosure, that they won't be prosecuted. So that what we call here the Section 204 agreements. We also have plea and sentence agreements. So if we put a charge to a corporate and the corporate chooses to plead to that charge, we can agree sentence, and there's a whole legislative regime that covers that. What we at the moment cannot, there's a debate about whether we can or can't do it. We are exploring doing these kinds of agreements while we wait for legislative reform, because I do think ideally this is such an important issue, such a significant issue, to leave it up to prosecutors and corporates to battle out is one part of the picture, but I think a public debate and a parliamentary debate about this kind of issue, because there are trade-offs that must be made here, and there are political trade-offs. And so the more guidance prosecutors can get from the law, the fairer and the more consistent the outcomes will be. So I agree with Kate, and I think we've also had other legal advice in the NPA saying desirable to have legislative reform. And it also gives us an opportunity to be more creative about fashioning a solution that is more, that fits better with our environment and our reality. But there's a lot we can do. The one thing I think we struggle with is agreeing to impose a criminal sanction. The one thing I forgot to say, we can also achieve disgorgement, right? A corporate can say, we did this, we made money. We saw at the commission, ABB purported, no, ABB did it with ESCOM. It disgorged its benefit that it derived from being involved in the corruption. There are many other corporates who come forward and say, we found corruption. This is the benefit we derived through asset forfeiture proceedings. We can make good. What we are not able to do that our colleagues in other parts of the world can do is actually impose a criminal sanction. So it's imposing a criminal sanction where you haven't had a criminal conviction. And that, there's a discomfort in the prosecution doing that without court intervention. The way the Americans, I think, achieve that is they emphasize publicity. So they emphasize publicly making available deferred prosecution agreements so that there's scrutiny of them, and whoever feels that there's been a gross injustice can comment at least. So if we were to do these kinds of agreements, we would have to be very clear that there are no secret deals. We can't have secret resolves with corporates. We would have to come out publicly and put in the public domain what were the trade-offs. There will be trade-offs, and to be transparent. So as I said, there's a lot that we can do with corporates who want to come clean, and we are engaged in several of those negotiations. They are complex, but where it's tricky is when a corporate says, not only will we disgorge the 50 million rand or 500 million rand contract, but as a sanction, we will also pay back double that. Now, nobody's knocking on our door to say we'll pay more, but I've seen how my colleagues in the US negotiate this, and that's the result that they achieve. And we get to piggyback on their might and their strength and their ability to get people to the table to acknowledge that not only do you disgorge, but you have to make good. You have to pay a penalty to show that you understand what you did was wrong and you won't let this happen again. So that
Thanks, Hermione. Gilbert, you wanted to respond.
Yeah, just briefly, Petrus, I think Kate alludes to the UK legislative regime, and you talk about legislative changes. Now, it would be very tempting to summarily adopt the UK legislative regime, but when one looks at it, it's got substantive procedural and substantive legal requirements for such agreements to be complied with. And I think Hermione is correct. There's a first hurdle what they call the evidentiary test. Is there already sufficient evidence either to prove beyond reasonable doubt or at least a reasonable suspicion that the corporate has committed criminality? Just applying that simple test, I think Hermione would agree, would be very challenging from a NPA perspective. So one needs to come up and say, we can adopt those rules, but we need to make it specific to South Africa, maybe same but different. And here I've been thinking about what if, and just by way of analogy with the SAU, I mean, the SAU has effectively created a tribunal where they can litigate outside of the normal processes. Now that's one idea that we should explore in terms of how can that be supplanted into a regime that ultimately manifests in PDAs, where there's a tribunal that just looks at PDAs. More so, I think the critical part is, and Kate, you alluded to that, is the NPA should still have a case, whether on reasonable doubt or on suspicion. Now, the complexities of these matters are such that, as Hermione says, the company comes to us and say, we want to cooperate, but we're way behind as prosecutors. How about working into those rules a regime where you then do a joint investigation with the corporates? I think the current approach is corporates call us in as consultants and say, do the investigation. NPA waits on the sidelines, or they do something on their side, but never do the two come together. But I think there's opportunities for us to then look at what is best practice and how can we then customize and tailor-make it for a South African scenario to address corporate criminality in a more effective way. And I think this discussion really takes us in that direction.
Thank you, Gilbert, because what I'm hearing and following on from what Hermione said, that there are cases underway or negotiations underway where the criminal justice system is working with corporates, but without empowering, and just forgive me, criticize me, point me in the right direction, but what I'm hearing is that without the empowering overarching legislation, it stops short. It stops short of the punitive sanction. It stops short of saying the facts that you've given are insufficient. Go and investigate further. Go and dig deeper before you come back. And then the point that you made earlier, Gilbert, and what are you going to do to clean up your shop to make sure that this never happens again? And am I correct that we don't have the muscle to drive any of those points yet? If I can throw it open. Yes, Kate.
Well, I want to go back to a point that's been made, but I think its significance requires repetition. We have to capacitate the NPA. We have to be in a situation in which these agreements can be meaningful. It's the point that Gilbert made. The NPA has to know that it has a case. Right? It has to have sufficient investigative capabilities itself to know what its case is relative to what it's being told by the corporate. Because the problem is, if the prosecuting authority doesn't have a case or know its case, then this whole thing is led by the direction of the corporate. And I mean, just to use the language that has been used for these DPAs, ultimately they can be concluded where they achieve standards like fairness, reasonableness, and proportionateness. Now, you won't know that as a prosecuting authority unless you have your own vantage point on the case, what has been done, what your prospects of success are in running a criminal process to its end. And without that capacity within the NPA, I just worry that it's then a corporate-driven process in terms of which you won't be assured as the prosecuting authority whether you've achieved a fair, reasonable, and proportionate outcome, because you just don't know how good the case is relative to what they're putting on the table as a compromise position. Thank you.
Yes, Hermione.
Yeah, so I think I heard you say that we are busy cooperating with corporates. We are still very
Working
much
with.
we are very much sitting on the opposite side of the table, right?
Sorry.
In our adversarial system. So it's still very much an adversarial process. So, you know, I was in asset forfeiture for many years and worked at the World Bank Star Initiative when these kinds of settlements, alternative settlements were first being mooted. And as an asset forfeiture practitioner, I was horrified that you could sit down with a criminal, whether it's a corporate criminal or an ordinary criminal, and start discussing ways of paying to get out of jail or paying to stay out of jail is how we saw it. And so for years I wouldn't even be part of the discussion because I didn't want to be tainted by that kind of perspective. Now, having spent 2 years looking at our challenges, there are many reasons to jump in here and roll up our sleeves and get into the muck to try and sort it out and have something that works. What is not an option is going on this trajectory that we're currently on, where very little prosecution of corporates is happening. You know, I don't know of many, right, at this point in time of serious multinational corporations. And, you know, so if our options are carrying on as we are with no accountability of any shape or form versus a less than perfect system where we find ways to mitigate the risks. And there are, we've mentioned a few risks, right? The risk of secrecy, which we can counter by insisting on transparency. I see a question about, you know, the degree of transparency. Will you turn over everything that has been uncovered in the investigation? Is that the kind of transparency you're talking about? I doubt it, but that's the risk we must mitigate and discuss as we fashion a solution for ourselves. Imperfect information, that is always a problem in any plea and settlement agreement. The corporate is always going to have more information or know more than the state will. And so there are also ways to mitigate that problem. You know, you say, well, you disclose the facts. If somebody comes out of the woodwork 3 months or a year down the line and actually proves that this is a lie, then either the agreement's off the table or we're back at the drawing board. You know, so I think we have to look at all the risks inherent in this kind of system, and I agree that there are many, but I agree that we don't have the luxury of saying, well, we don't want to go there because this looks like we're going to give corporates a free pass. Anything but. I think we have to find ways that ensures that there is fairness, that there is justice, but also that there is efficiency and there's some speed in the system. You know, the time it takes, even in the UK and the US, you know, to complete a prosecution of this nature, it's usually 5 to 7 years after the fact. In developing countries like ours, it's 20 years after the fact, where, you know, it's so stale. Some of the prosecutions we are dealing with, you know, people are dying, memories have faded. So we also deal with those challenges. So I don't think there's an option not to engage with this and do the best we can to try and mitigate the risks that there are. Thanks.
Thanks, Hermione. Karam, if I can ask you, what do you believe will be the reaction from a civil society point of view to proceed, as Hermione suggested? It's not a perfect solution, but we need a solution, even if it is imperfect, that produces a result, even if it's not the best result. It is better than no result.
look, I mean, I think it's just so critical that we have the debate, you know. So I think the obvious reaction from quarters of civil society, from those who've been crying out for accountability to address this sort of deep-seated accountability deficit, is that you know, there's no quick fixes. We can't just let corporates off the hook. You know, we need to have some kind of corporate accountability. But I mean, the base that we're working from, as Hermione's just described, is so low. You know, we've seen so little corporate accountability, and the corporate so-called accountability that we've seen has been really, you know, somewhat almost irregular. You know, I mean, I don't know if that's the right way to characterize it, but you know, what do we make of the McKinsey agreement at the Zondo Commission that they're going to just pay back the money? You know, that seemed very curious when that happened. Even the kind of scandal around what's happening with Steinhoff and sort of who's doing the investigation, who's paying for the investigation, what's being investigated, you know, all of that is very, very murky. So I think we can't be purist as civil society, but I think as civil society we can just continue to kind of hammer the principles that any kind of reform that we have has to be consistent with these notions around accountability and around transparency. And we're not going to support a deferred prosecution or non-trial resolution regime which doesn't do that. But that doesn't mean that we can't, you know, that we can't have something, and that that it's something that could be uneven, that could you know, create other challenges. But we're seeing this movement in jurisdictions like Australia, in Kenya. You know, this is not something which is unique to the UK and the US. So there are other, you know, similarly situated jurisdictions like ours that are using this arguably somewhat effectively. I mean, the Kenyan case of the agreement that they were able to negotiate with multiple banks in Kenya around money laundering would be a success story, they would say. I saw somebody in the chat spoke about the car wash case in Brazil. Yes. You know, so yeah, you know, and I think civil society can stick to its guns and be principled, but I think we have to have an open debate and look to move the needle.
Thanks, Karam. And Kate, if I could ask you, maybe it's just the lawyer in me, but from a jurisprudential point of view, do you anticipate there being opposition to deferred prosecution agreements for a sort of a debasing of the criminal justice system where not everything is resolved by the day in court? Do you see any serious challenges from that quarter, from the legal purists?
Well, from the participants themselves, you wouldn't have opposition, right? Mm-hmm. Because it's a voluntary and agreed landing point between accused and prosecution service. I think it's important to get Karam's reflections about how civil society and the public's desire for accountability can be heard and attended to, notwithstanding these types of agreements and some of the trade-offs that are involved in them. I think that the one point that I do think needs to probably come across, and which we've touched on a bit, is the point about the sheer complexity of these types of crimes. Deferred prosecution agreements are not generally available, to my knowledge, in any jurisdiction for all crimes. They are a model for a very particular type of crime with very particular features, including amongst them the sheer complexity, the levels of sophistication at which the crime is perpetrated, the expertise involved in perpetrating them. So they tend generally to be available for economic crimes, for want of a better description. And I think in that context, you do quite a bit to calm the criticisms that might come otherwise, because you realize that there really is great complexity in them. I mean, I think the German regulators took 3 years even to be able to think about a prosecution in Steinhoff, right? And your 7-10 years is actually very realistic when you're dealing with high level complex swap agreements, those sorts of things that require great expertise at the financial and economic level. So I think there's likely to be concerns about DPAs if they are perceived as being an alternative to an accountable criminal justice process. What I'm trying to emphasize is the response to that, in my view, is properly to understand the complexity and the sheer challenges in prosecuting those cases. And if you appreciate that, then the space opens up for some alternative mechanism like this.
Thanks, Kate. If we could jump ahead and just imagine a South Africa with DPAs. And this is a question for the panel generally, where do you think it would need to be housed? Do we need another Chapter 9 institution that is going to be responsible for the adjudication and enforcement? And because these have got long monitoring, if you use the US as an example, they can be subject to monitorship for 5 years afterwards and more. And what would be necessary from a structural point of view to be able to provide the right balanced oversight, the decision-making, and the follow-through to be able to make this happen? Any thoughts? Gilbert, I can see you've got a thought.
Well, I would imagine that the NPA would claim for itself sole propriety rights over this phenomena, if I can put it that way, and maybe rightly so, but that it may be caught up in some politics, internal politics, and may I throw in by the same token, Petrus, the role of regulators, for instance. And
I was wanting to get to that, Gilbert.
How does that manifest in where this ultimate power resides? Because it's a big responsibility. I think the NPA, as currently structured, probably doesn't have the capacity, as Hermione correctly alluded to, but it would be a journey to create that capacity. And I think if you look at both the Constitution and the NPA Act, ultimately, this is a deferred prosecution by its very terminology. And the head of the prosecutions is probably Dominus Litis, whether it is a deferred one or not. And I would argue that's where it sits. But I would imagine even Hermione would say, but as investigating directorate, I should be, similar to the UK, a designated prosecutor to decide on these agreements, provided I comply with certain procedural and substantive requirements. Housing it outside may have other implications, but that doesn't preclude the NPA from, for example, using other existing institutions like regulators. Let's say Hermione decides, let's give a certain corporation an agreement. She could easily ask the SARB or FinServ to play on their behalf a monitor role to see, will the conditions be met? And I think there is a multi-disciplinary approach that can be implemented by the NPA to strengthen itself and its resources to deal more effectively with this regime.
Other thoughts? I mean,
I like what Gilbert said earlier about exploring the SIU tribunal, what as an option, because I think, the prosecutor will remain Dominus Litis when it comes to a decision to prosecute, and that's what the Constitution says. So if the prosecutor is empowered to enter into a non-prosecution agreement, a deferred prosecution agreement, or even a plea and sentence, a plea and sentence, it will just go through the normal court process, but it may even be appropriate to create a forum where the expertise exists. Like the tribunal, for example, that you you have that court filled with expertise, including, some of the other experts to sit as assessors in a matter. And you say it's a forum not only to deal with plea and sentence agreements, but it's also a forum to deal with non-prosecution agreements. So before a non-prosecution agreement can be, made an order of court, it has to be presented to this tribunal. Of course, you don't want to undermine the benefits of allowing the two parties to reach a pragmatic agreement, and then a third party sort of says, no, I don't like this, and all that work is undone. So you want to have guiding principles. You want to have, rules that prosecutors and corporates know in advance that these are the things that are going to be looked at. So in the US, for example, they look at how early in the process did the corporate come to law enforcement and disclose that corruption is happening? How long between discovering corruption and reporting the matter? In the US, they look at the extent of cooperation and disclosure. Some corporates, tell me that they've spent hundreds of millions on the investigation. So when you say to them, and what about a sanction component? They said, you don't think we've suffered enough, but that there is some compensation for the resources put into uncovering what went wrong. And then, the cost of a compliance program, as Gilbert refers to ensure that we build a culture of accountability. Those rules can be specified, and you have the tribunal examine the agreement against those rules and say, is this fair, objectively fair? That's one way of getting us past this. I think I agree with all the participants who say you can't embark on this and leave yourselves in the hands of corporates entirely to do the work, to do the investigation. And I think we exist in a system where I don't think there's enough confidence in the NPA's ability to negotiate these. So I do think in our system, you would need an external review of these agreements and a systematic review of these agreements. But there's the other challenge, the one Gilbert alluded to, and I think I saw in the comments, Tabitha asking, does this mean, one set of justice for the rich and another set of justice rules for the poor? You have to make provision, you have to explain to the public how this is not about letting off people off the hook who can pay to be off the hook, but to give them real confidence. They must feel that the state has the capacity, if it needs it, to be able to investigate. But what you'll find in this country and around the world is that sometimes, more often than not, the expertise to investigate, to properly understand a very complex transaction will never be in the prosecution. You'll never be able to keep those people on state salaries who can do that kind of work. So the state will always be going outside to get input. And, I often worry about how dependent, everyone worries about how dependent the state is on external private sector support. And there again, there has to be a balance struck, right, between what can be maintained within the state and what needs to be in-sourced. And when it's in-sourced, how then do you ensure that public objectives are met and not private interests are ruling the roost? So I would say that there are ways to get around, and we fairly creative society. I think we should be able to come up with a regime here that speaks to our unique challenges and helps move us forward.
Petrus said in jest,
Yeah.
perhaps there's life for the commission after all, in a different form.
Well, I mean, the point that struck me with from what Hermione was saying is, and it's hard to disagree with it, is that the need for external oversight. If you're going to try and ensure a level of consistency in even if punishment can be meted out, a level of consistency from one case to the next, some sort of balancing of the different interests, being able to make those judgment calls as to how soon did the corporate come forward, how much have they invested in uncovering this or spent on uncovering this themselves, and the like. So I think that, well, it's hard to imagine getting away from some external judicial oversight completely. Kate.
Can I just add something to that? Because when I was looking at the requirements of fairness, reasonable and proportionate for these types of agreements to receive judicial sanction, for example, in the UK, it made me think of class action settlements. You know, class action litigation is somewhat new in our country as well, but one of the requirements there, because there is this public interest element to that litigation and the rights of particular members of the class who may not even know that they are class members at the time the litigation is brought, you always have to have that settlement agreement approved by a court against a measure that is very similar, right? So it's not your average private litigation where if something is to be made a court order, of course, a court doesn't just give its stamp of approval, it does interrogate it to some extent, but not to the same extent that's required in class action litigation, where the court is actually playing a guardianship role for the interests of those who are not necessarily before it. I think there's a great parallel with this. You need to ensure that the comment, Hermione, that you referenced from the participants, you know, is this the easy way out for the rich and is only available to them and not available to the poor? I mean, those sorts of concerns about these agreements, I think, are valuably met if there is some external oversight. You've bargained with the corporate, you've got a deal as the prosecution that you can live with, that you think achieves objectives, but just the method of going before somebody, whether it's a tribunal or whether it's our courts as they exist now, and asking for an endorsement, I think helps give accountability to the process.
Thanks, Kate. Just the panelists, administrators, because you can't all see the question and answer the questions that have been posted, I've started to post some of the questions in the chat box. Can you see them on the side of the screen? Are there, and if you could continue to do that, it'd be useful. Are there any, can I ask you if anything catches your eye that you would like to specifically respond to? Yes, Hermione.
I have been going through them. I mean, I think that the last question around is this a good idea in South Africa? Should we rather not be focusing our efforts on fixing the challenges in the NPA and the police? I certainly don't see it as an either or. Both need to happen, and they need to happen very seriously and very quickly. But you know, corporates made a lot of money from corruption in South Africa, and we're not exactly that you know, the fiscus could certainly use the return of a lot of those funds. So the SOEs, for example, who lost vast sums of money, you know, could benefit from a re-injection of some of these DPAs. The settlement, the ABB settlement of 1.6 billion, that's a significant settlement. You know, McKinsey, I think, is now on it's paid $1 billion, and it's in Eskom, and now I don't know, 800-900 million in Transnet. That's significant. The litigation going on to recover the proceeds of corruption by Transnet in the 1064 procurement, if we could resolve those cases with deferred non-prosecution, deferred prosecution, or plea and sentence agreements, and find ways that do justice, we will save ourselves 10 years of investigating and litigating with very uncertain outcomes. The predictability in the criminal justice system at the moment is it's not what it should be. And so I think if we can anticipate or advance these kinds of settlements, they are a real source of revenue. And let's not forget that one of the reasons this is desirable is often there are individuals in the corporation that is guilty of the corruption, obviously. And this is not about giving those individuals a free pass, because the individuals are still required, should still be held accountable and should go to jail for corruption. What this is about is separating those individuals from the corporation that they used or shielded by, and saying, you and all the employees that weren't complicit can continue, but we need to find a way to remove the rot and have the rot go to jail. And if you're going to work with us on that, that's really great, because you know much more than we do. But yeah, to maintain obviously independence and maintain accountability in that process, that's what we need to do. So yes, I can think of lots of reasons why you would prefer not to do this, but I don't think that's a luxury that we have anymore. So that would be my answer to that question.
Point taken. Karam, if I can call on you from your experience in civil society, a question has been posed, sort of a constructive one, as to how can we lobby government for legal reform? What are the mechanisms for the interested party out there to be able to contributing to lobbying government for reform of this nature?
Well, I think this is a start, possibly the start of something. I mean, we've battled, to be honest, when it comes to lobbying government around significant legislative reform. I mean, we think about the procurement reform bill, which was released in 2019. We've been writing extensively to the Minister of Finance to get access to the thousands of comments which have been received from the public. We haven't had any success in doing that. The timetable for Treasury to even bring that bill before public comment is not until 2022. It's a bill that came out in 2019. We know from the SIU report on PPE, the challenges we have around procurement, so, it's completely uneven at the moment, engaging with government and trying to get a sense of the urgency that's felt around significant structural legislative reform, except the commitments that have been made to the Zondo Commission, the participation, except the engagements that have been made around leadership appointments and around trying to recapacitate certain institutions of state. But at the moment, it's we not knock on open doors, but it doesn't feel at the moment that there's an open discussion taking place with government around criminal justice reform. So I think as civil society, that's something we need to continue to think about. And I'm sorry to be so pessimistic in that response.
Thanks, Karam. If I could pick up on a point that was triggered by what you made reference to, Kate, about class actions. Has anyone picked up or heard of any deferred prosecution agreement that has incorporated an element of compensation to victims of the crime? And if not, should it be a consideration?
Can I take a stab at it? In my days in asset forfeiture, when we did pyramid schemes, that often have victims, hundreds of thousands of victims. I remember marches by those victims on the NPA buildings demanding that, demanding that the pyramid be maintained until their benefit is paid, and then they'll,
Yes.
you know. But and you know, I've been involved in settlements where we've had to work out how we're going to pay the benefits to victims. In corruption, invariably the victim is the state and the fiscus. So invariably the debate you'll have is, and I see there was a question to this effect, you put the money into the general revenue account, or do you put the money into a dedicated account that will fund law enforcement into the future? We have both options available to us in South Africa. We have the criminal assets recovery account, in which settlements of this nature could be transferred, but equally, you know, so the SOEs probably as victims of the corruption would equally be standing in line to say, well, if the money is to be recovered, can it go back to where? And you know, in government, there's that debate. Treasury says, well, no, this is money that has to come to the fiscus for today's government to decide how we distribute it. So there are debates about what you do with the money and how you get back the money, and that's why that's another public debate that needs to happen, you know, that Parliament gets engaged in making those calls for South Africa. I think I'll leave it at that for the moment, but the horror of adding more complexity to a negotiation of this nature is I think what makes me very nervous. So I would like to keep it as simple as possible, because already all of this draws prosecutors into an area that we are very poorly equipped to navigate. You know, we don't, this is not our business. We have criminal standards and criminal charges that we have to prove. This involves all sorts of complex curatorships and in working out claims and deduct, you know, this is not our bread and butter. So ideally, people with that kind of expertise should be engaged to be part of that solution.
Petrus,
yes, Gilbert and then Kate.
So your question is not only about restitution to victims. I see one of the participants has put a very apt question there. What is the maximum penalty that can be imposed? But more importantly, ask, does this do justice for the social harm caused by corporations, for example, in cutting our SOEs? My sense, looking at various DPAs, is that the conditions imposed certainly seek first and foremost restitution to victims of the corporate crime. Over and above that, there's a penalty or a punishment clause in it, which also seeks to address that aspect. And then I think thirdly, as I touched on right at the beginning, it's the rehabilitation of the corporation and its ethics and its culture. So there's no maximum penalty per se, but I think in arriving at what would be considered fair, reasonable, and proportionate, all of these factors will need to be taken into consideration and say, does this corporation actually need to make restitution to Transnet, for instance, for the harm, not only the direct harm, but the indirect harm that its actions has caused, for example. And I think those would be relevant considerations. It does beg the question that Hermione raises, whether a prosecutor would have the necessary negotiation skills to navigate what is otherwise a complex area of how do you then set that. I see in the UK, or is it the US, they actually have a certain formula in terms of how certain amounts and penalties are calculated. Let's say X percentage of the corporate's turnover. and there's always a disgorgement of profits as well. So I think that the mechanism is wide enough to incorporate multi-purpose objectives and not only purely just prosecution.
Thanks, Gilbert. Kate, you wanted to add?
Yes, I just want to add something that might loop us back actually to a point that Karam made at the beginning. Hermione made the point a moment ago with which I agree completely. You need to understand the nature of corruption as an offence to understand who the true victims are. It's generally the fiscus or it's a particular SOE, etc. But Karam, at the beginning, you were telling us about some of the transparency initiatives, and you mentioned work or recommendations that were done around whistleblower protections. And when we were thinking about compensation to victims, the role that whistleblowers have played in disclosing or at least requiring some light to be shone on corruption, I think it might be interesting to give some further thought to within the consideration of who the victims are of these types of crimes and when these types of agreements are being concluded. Not to add more complexity, Hermione, I know, to an already difficult task, but the whistleblower who blows the whistle loses their position because they're pushed out of the SOE or the organization, who struggles thereafter. I think that they're a category of victims for which more attention could be given and consideration.
Thanks, Kate. Panelists, I'm afraid that the hour and a half has flown past, and I've got to call the session to a close. I think the overwhelming sense that comes out of the discussion is that there is scope, there is space for a new solution to enhance our criminal justice system and to bring people to account or organizations to account with greater speed and effectiveness. We look forward to seeing this debate enter the public domain on a wider forum, and encourage all of you that were listening to this webinar to not forget about it and also look to make your contribution when the time comes. But it leaves me just to sincerely thank our panelists for having given up of their time to participate in this discussion and to do so enthusiastically. Thank you all, Karam, Hermione, Kate, Gilbert. Thank you so much. It's really appreciated, and have a good day. Thanks.
Thank you.
Cheers. Bye.
Bye-bye. Thank you.
Cheers. Bye.
Thanks, Petrus.
Colleagues.